afternoon, everyone. I'm Bridget Dehart, ADEA's Director of Federal Government Relations and Advocacy. Welcome to Advocacy Insights, understanding the impact of the One Big Beautiful Bill on student financial aid. Our speaker today has a lot to talk about, and it is good for us that he is one of the most knowledgeable people on the topic. We will have time at the end for your questions, so please be thinking of them now. John Fansmith is the Senior Vice President for Government Relations and National Engagement at the American Council on Education, where he leads federal advocacy efforts on behalf of the nation's colleges and universities. He has a bachelor's degree in history from Georgetown University and a master's degree in government from Johns Hopkins University. With that, I will turn it over to John.
Well, thank you, Bridget, and thank you everyone for joining. Today, I know August is a tough time to get people to focus in on what's going on in Washington. It's such a tough time to do that even Congress takes off and leaves Washington for the month of August. So your attention to it is doubly appreciated. I'm also going to caution everyone up front that I am fighting my way through a cold, as you may hear in my voice. So this will be an interesting test case of the effects of DayQuil on public speaking. So bear with me if I confuse a few dates or terms, but hopefully we'll have a little bit of fun as we talk about something that sadly is not particularly fun, which is what is going on here in DC, especially around reconciliation. And to talk about that, I'm going to bring some slides up, so bear with me as I do that. So the reconciliation bill, a little bit of background for those who might not be familiar with it. Reconciliation is a budget process used by Congress. It has exceptional authority within congressional procedure. The big important difference about a reconciliation bill versus a regular bill is that a reconciliation bill can pass with a simple majority in both chambers. So the filibuster, which you often hear about in the Senate, that requires 60 votes for legislation to advance, doesn't apply to reconciliation. As a result, we have seen reconciliation used basically in the first 2 years of every new administration, going back several administrations. This is true for the Obama administration, for the first Trump administration, for the first Biden administration, and here we are in the second Trump administration, again, doing a reconciliation bill. The bill as a whole is an enormous package of legislation. Overall, it will have an impact on federal spending and savings of about $4.5 trillion. It's going to add over $2 trillion to the deficit. It touches on an enormous range of federal policy areas, most to do with taxes, but certainly things like Medicaid had an enormous impact. And there was a very healthy portion of this bill that was focused on higher education. And in particular within higher education, as you would guess for a bill that talks about spending, the student aid programs, which is where the bulk of federal money around higher education is. And I'm going to go through a few of these, starting with Pell. Obviously, Pell not directly relevant as an undergraduate focused program for dental educators, but given the pathways through to graduate education and the fact that a number of very substantive changes to the Pell grants were made, I thought I'd talk about those very briefly. The biggest change in this bill was the creation of what's known as workforce Pell or short-term Pell. This expands the existing Pell Grant program to students who are in what are considered short-term programs, programs with a length of 150 to 599 hours, generally between 8 and 15 weeks in length. These are not degree programs. These are not certificate programs. These are generally skills-focused programs. So think about something like an HVAC certification or a welding classification. There has been a lot of bipartisan interest in getting more money into these areas, allowing for more of this kind of training short of a degree. There's always been a debate between Republicans and Democrats about the best ways to do that. And they essentially resolved that in this bill by making compromises on both sides. Democrats agreed to allow for-profit institutions to be eligible for this program, despite concerns Democrats had about fraud and abuse in that sector. Republicans, in exchange, agreed to a number of demands by Democrats for strict guardrails around what kind of programs could participate in. And those guardrails are actually quite stringent around how long the program has to be in existence, what completion in the program looks like, earnings and outcomes from those programs at levels that frankly would be very, very difficult for a lot of degree programs at both the undergraduate or graduate level to meet. So that program will be going into effect as of July 1st, 2026. You'll hear me use that date a lot. That is the start of the federal financial aid year, as I probably don't need to tell everyone here. It's also the start of when most of the provisions in the reconciliation bill around financial aid will take effect, with a few exceptions. The next thing around Pell, very simple thing. The Pell Grant program is running a shortfall. This is when the money Congress has provided for the program is insufficient to meet the demands of the program. Congressional Budget Office estimates that Pell will have about a $97 billion shortfall over the next 10 years. Historically, what happens when there is a shortfall, Congress has two options. They can spend more money, or they can reduce the program, make it less generous, constrain eligibility to lower costs. When we last had a really big shortfall issue, which was the post-Great Recession period, 2010, 2011, Congress basically did both. They poured a lot of money into the program. They also started cutting out a lot of eligibility provisions. There was some efforts in the House to fully offset the shortfall by making changes in eligibility that would have been really harmful to low-income students. Those did not follow through in the Senate. The Senate essentially took $10 billion, said this will buy us about a year and a half's worth of peace around Pell funding, gets them through the FY26 fiscal year, and essentially pushes the problem down at least to fiscal year 27 discussions. So a little bit of a reprieve to figure out a longer-term solution there. Finally, and this is somewhat of a confusing one, there was language in the final bill that said that for Pell Grant recipients who would receive scholarship or grant aid from non-federal sources that would meet their full cost of attendance, they are not eligible to receive a Pell Grant. This was intended to address the sort of anecdotal concerns members of Congress had heard about why would a student who's on an athletic scholarship and is getting a free ride from a school, why would the school get to pay off some of that free ride by using a Pell Grant for that student? The number of situations in which this applies is very small as far as we can determine, but by reversing the order of Pell being a first dollar program, it has the likelihood of causing a lot of harm in the student aid calculations, how you package. Historically, Pell has always been the first dollar awarded to low-income students, and most state systems are built off that. I was talking with some tribal college and university leaders the other day. They have tribal scholarships that provide support that are built off of Pell awards. So this is a bill that causes a lot of confusion in implementation to address what otherwise is a very negligible problem. So that's something we're going to have to deal with a lot more in the implementation process, which we'll come to a little bit. Moving off of Pell into an area I think of probably pretty significant interest to this audience, the reconciliation bill as it stands really represents probably the closest thing we're going to get in the near or probably even long term to an HEA reauthorization, and in part because it addresses a number of things around lending and repayment and accountability that are pretty core elements of what's in the HEA, but Congress has not been able to come to a conclusion on an independent HEA process to move forward. So there are massive changes to how we understand the lending system and the accountability structure for colleges and universities in the reconciliation bill. The loan piece is first and foremost one that will have the most immediate impact, certainly for dental education programs. Everyone probably knows by now that while the House had a pretty large package of loan changes, including changes at the undergraduate level, the Senate preferred instead to leave undergraduate lending as is and focus entirely on the areas of graduate and parent borrowing. And they did this in a couple different ways. In one case, probably the one that's gotten the most attention, is they have eliminated the Grad Plus borrowing program. This was the program that allowed graduate students to borrow up to cost of attendance. That program will no longer exist as of July 1st, 2026. The one caveat to that is that for students who are currently enrolled in Grad PLUS, they will remain eligible to borrow in Grad PLUS for up to 3 academic years. So Grad PLUS is going away. It will not be available to new borrowers, but for current borrowers in the program, they will be able to continue borrowing in that program for up to 3 years. Parent Plus, the changes, the program will continue, but there are new borrowing caps that have been put in place alongside the caps around Stafford lending that have been expanded to try to accommodate some of the need for graduate borrowing, which is the other component of this. Alongside the elimination of Grad Plus, the reconciliation bill greatly expands the unsubsidized Stafford borrowing limits, but it does it for graduate programs in kind of an interesting way. They disaggregate between 2 categories of graduate borrowing, and I think there'll probably be a lot of questions about this, and we can answer them to the best of my ability. Some of these decisions haven't been made yet, but the legislative language in the reconciliation bill essentially says that there are 2 categories of graduate education now. The first is what is known as graduate education. This is intended to be programs at the graduate level, so post-BA, with structured course time of 3 or fewer years. The committee's intent with graduate borrowers is essentially master's programs or graduate certificate programs. The second class of graduate borrowers are known as professional borrowers, and this is programs of length of 3 or more scheduled classroom instruction. The committee's intent was to cover PhD programs, dental degrees, MDs, JDs, MBAs, terminal degrees, professional degrees. I probably don't need to tell all of you that amidst the greater world of higher education, there are a lot of cases of programs that will be occupying a big gray area around those distinctions, and this will be something that when we talk about implementation, that'll be a big factor. The reason those distinctions matter is those distinctions carry very different borrowing limits. For the graduate level borrowers, a student is able to borrow $20,500 each year, and they have a cumulative limit of $100,000 across the course of their studies. For professional borrowers, they are able to borrow $50,000 a year, up to an aggregate maximum of $200,000 across their academic career. It's also worth noting that if you are a professional borrower, that $200,000 limit also includes any prior graduate borrowing. So if you went to grad school and got a master's degree and you spent $80,000 doing that, your aggregate limit doesn't necessarily allow you to borrow another $200,000 for your professional degree. You'd actually only be able to borrow the difference between the two, which in this case would be $120,000. So these limits, particularly for students who may be enrolled across the course of their academic careers in more than one graduate level program, obviously very different than what we've seen, especially with the health services exemption that's currently in place. Couple other tweaks to borrowing that were in the bill. And I should mention the Parent Plus borrowing program. You are allowed to borrow as a parent on behalf of your child enrolled in post-secondary education. And this is much more prevalent at the undergraduate level, but those caps are $20,000 annually to a lifetime maximum of $65,000 per child. Other change is something actually that we're pretty happy about, that we have been asking for of Congress through the reauthorization process of almost 2 decades at this point, is giving institutions the ability to limit borrowing of students based on clear indicators across student outcomes or other things. You can't base it on student profile, but you can say that programs can have different borrowing maximums. Institutions can cap borrowing below the levels. Probably less relevant for dental education programs, but it's been something that particularly community colleges and others that might have low-cost programs where students would borrow as an entitlement to the maximum amount, even if that behavior wasn't in their own best interest, the institutions had no ability to block. So that's something that was included in this bill. Moving on to the repayment piece. The repayment piece reflects what we've seen in the number of proposals in both the House and the Senate, both Republicans and Democrats, essentially moving away from this kind of continuing growth of the numbers of different repayment options that are out there. I think depending on how you define it, there's something along the lines of between 8 and 13 repayment options available to borrowers, depending on which criteria they meet. This would move to two specific loan repayment programs. One would be a version of the standard repayment program. It would allow for a 10-year window for repayment with a fixed loan amount for each repayment. That 10-year period could expand to up to 25 years based on the loan debt taken out. So the larger your borrowing debt, the longer you have in that standardized repayment program to repay. The new income-based plan looks a lot like what we think of with the IBR plans. Generally, there's a 10% income calculation. It allows for a minimum payment of $10 that you can go down to if you don't have sufficient income. It allows for, there's a number of provisions to assist with it. So it is essentially looks a lot like kind of a hybrid of what we saw in IBR and the Obama administration's pay repayment program, income-based, flexible payment. You have to keep repaying through the lifetime of the loan. Forgiveness only comes after 30 years. The other piece around repayment that I know will be of interest to this community is around the medical and dental residencies in public service loan forgiveness. There had been a push for getting the residency period or internship periods for dental and medical students to qualify for the purposes of your repayment term, to qualify for the 10 years of repayment in public service loan forgiveness. That ultimately was not included in this bill. Those periods of repayment will not count towards public service loan forgiveness. The other big, and we will see what the impact will be, but it is certainly new and different, is that there was a robust accountability provision added to the reconciliation bill for colleges and universities. The House had put forward a risk-sharing proposal. I think I probably talked about that proposal a number of times before ADEA folks, but just a quick reminder, this was a proposal that would essentially bill institutions on an annual basis for a percentage of the unrepaid loan volume of their students once they'd entered repayment. Very complicated calculation, looked at different categories of borrowers. The House had put that forward. It is still a strong priority of House members. The Senate had very little interest in that as an approach. I was never really seriously considered by the Senate. Instead, the Senate went with something that looked very close to what had been introduced in the bill at the beginning of this Congress by Senators Cornyn and the chairman of the Health, Education, Labor, and Pensions Committee, Senator Bill Cassidy. This would actually look a lot like the gainful employment approach that is in regulations of the Department of Education, essentially saying that we are going to measure the merits of individual programs at institutions by how their graduates perform solely on the basis of earnings. And the way this would do this is, and it splits it up between graduate and undergraduate education, but at the undergraduate education level, every program at an institution, their graduates 4 years after they graduate, their average earnings would be assessed, and if their average earnings, and these are completers only, graduates in 4 years post-completion, if their average earnings are not higher than the average earnings of high school-only graduates who are 25 to 34 years of age, either within the state or if the majority of the students in that program are from out of state against a national average, if they don't exceed those earnings levels, that program is no longer eligible. And if they don't meet that threshold for 2 out of 3 years, that program no longer has access to federal student loans for at least 2 years. At the graduate level, it's the same calculation. It's a comparison of earnings. The difference would be they would compare any graduate degree holder against the earnings of bachelor's degree holders within the state who are 25 to 34 years old. So for undergraduate, they're comparing AA and BA recipients against high school graduates. At the graduate level, regardless of the program, whether that's a master's or a doctorate, JD and MBA, whatever it might be, it is compared against the earnings of BA recipients within the state, 25 to 34 years old, 4 years after completion for the program. Again, the penalty, if you fail 2 out of 3 years, they don't need to be consecutive years, just 2 out of 3, is that the program, that particular program, it's not institution-wide, is ineligible to participate in the federal student loan programs for a minimum of 2 years. They can apply for reinstatement. They would need to be able to meet that threshold test to be eligible for reinstatement for federal student borrowing. Other forms of federal aid would remain available. This only applies to Title IV programs. So there are health loans. It's not entirely clear. I think this might come up in the implementation process, whether there would be bars around that. But the law itself doesn't seem to amend those other laws. So there's an argument to be made that this would just apply to Title IV student lending. That's what we know right now. There are a couple things we can see already. We were talking before we started today that the average borrowing amount for dental students is about $312,000 across their academic career. As we mentioned, a cap in the aggregate level of $200,000 is going to mean that a number of dental students will need to borrow in the private sector or bring other resources to the table to finance their educations. We know that there will be problems around the available borrowing amounts there. We also know with this accountability piece that there are going to be some professions where you need to have graduate level education. The ones that particularly come to mind are a number of teaching education fields short of teaching, social work, counseling, forms of therapy, where graduate education is required, but as a society, we don't pay very highly in those fields. And so what we've tended to see when we've looked at preliminary data about what the accountability will mean is a relatively small number of programs are likely to fall under the accountability threshold, but those will be clustered across a range of certain fields. So certain areas of post-secondary education, especially at the graduate level, are going to be more targeted than others. Which brings us to next steps with all this. As I've talked about, this is a pretty massive overhaul of the existing federal lending and oversight space. I've also talked about the fact that the implementation date per the bill is July 1st, 2026, start of the federal financial aid year. As you may know, to make regulations that are in effect by the start of the July 1st, 2026 date, the Department of Education has to meet a master calendar requirement of finalizing those regulations by November 1st of the preceding year, meaning that they will have to pass regulations, the regulations they'll need to implement the One Big Beautiful Bill for next year by November 1st. We are discussing this on August 7th. I don't need to point to the calendar. That's not a whole lot of time to do a formal rulemaking process, draft and finalize regulations, and have them in effect by November 1st to meet that deadline. Congress in itself is also doing some other things that may impact how tight that timeline is. We are expecting to see, at least from the Senate Health Committee, a FAQ document sometime soon that will address issues and concerns they have heard about the language in the reconciliation bill. It's probably worth taking a second just to talk about how abnormal this process is and why reconciliation doesn't work well for doing really complicated restructures of things like student lending and repayment and accountability. This bill moved in a very compressed time period. The House introduced their version back in May. It went to the Senate in June. The Senate reviewed House language for about 2 weeks and then introduced their own language that produced massive changes. And then the bill itself moved through the process, including going back to the House, being passed by the House and signed by the President by July 4th. All told, for many of these proposals, the first time the language around them was publicly available was about 5 weeks before the bill was passed into law. That does not allow for a lot of time for stakeholder viewpoints. It does not allow a lot of time for analysis. And what we've seen is hastily drafted bills tend to have big gray areas, unanswered questions, and lots of uncertainties. So the implementation of this bill, this process, always very important with any new piece of legislation, but given the size and the scope and the impact, and then the speed with which it's done, and the already pretty obvious ambiguities in law, this is going to be a very critical implementation period. So that the FAQ's guidance from the Senate is going to try to help clarify their intent. That is important as the department goes to regulations. A large part of what regulations are intended to do is to clarify what congressional intent was and make sure that the bill is enforced in such a way that it reflects that. So there will be helpful, the Senate guidance can be very helpful in addressing some of the problem areas we already see coming. The Senate, at least, and possibly the House, has also talked about doing a technical fixes bill to the reconciliation piece around the education provisions. Some of the things in the law where the language is actually written in a way that contradicts congressional intent need to be changed. This is, as you can guess, a problem for a lot of reasons. The Department of Education is rushing to do regulations on this bill by that short time frame of November 1st. If another bill is passed by Congress that amends what is in the language, to be very clear, the Department of Education has to implement based on what the law says. They don't have the flexibility to say, we know they didn't really mean that, so we're going to do it this way. A technical fixes provision would be very helpful to clear up some of these problems, but it also further shortens the time frame and adds another layer of difficulty to getting this bill into law. A reasonable person might say they should simply delay the implementation date back a year, but that, at least in this political environment where this was President Trump's first and foremost legislative priority, it doesn't seem very likely. There are some discussions about delaying implementation of certain pieces of that. So far, there haven't been a huge amount of political support in the Republican Party for doing that. Which leaves us with the department's rulemaking process. They will be holding public comments, or actually, they held public comment this morning. I should know that because AC testified. My colleague Emmanuel Guillory was there. He had a robust 3 minutes of public testimony to talk about our myriad concerns with this reconciliation bill, and a number of other members of the public have done so as well. August 25th, which is coming up fast, is the deadline both for public comments to be submitted to the Department of Education about their rulemaking process, as well as for people to be nominated to serve on the 2 rulemaking committees that will implement the education provisions in this bill. Those 2 committees go by acronyms, which is somewhat unusual for rulemaking. The RISE committee, which will deal with most of the loan changes, and the HEAD committee, which will deal with most of the accountability and most of the other non-financial aid pieces in the bill. Don't ask me what RISE and the HEAD stand for. I read it, I can't remember. They're very complicated. I remember a HEAD had something like 11 words in it, which a HEAD only has 5 letters, so you can see what kind of an acronym they put together for that. All of that, once they get with the rulemaking committees, they will probably be a very expedited rulemaking process. They've already done this year around PSLF, where they did a 1-session rulemaking. Normally, rulemaking is 3 sessions across 3 months. Given that November 1st timeline, they will probably have more than 1 session, but have to push for those, maybe multiples in a month to try to meet the deadline. And then we'll have the regulations going forward. So that is where we stand now. 2 other issues I mentioned that I did want to talk about because they're impactful for graduate education. The first is the funding situation, and Congress is currently working on the fiscal year 26 appropriations. Fiscal year 25 ends on September 30th of this year. October 1st is the start of the federal fiscal year. In all honesty, Congress has not been doing a whole lot of work on appropriations while reconciliation was going on. Reconciliation was really the only thing of primary importance to leadership through the first half of this year. And as a result, they are playing catch up. The Senate is moving bills. Just last week, the Senate Appropriations Committee approved their Labor, Health and Human Services Education Appropriations Bill. It is notable because it was a mostly bipartisan bill, and what it mostly did was preserved existing funding for the programs that are in law. We'll talk about the House in a second, but the president in his budget request had requested massive cuts to non-defense spending, overall cut levels of about $163 billion less for this fiscal year than the preceding fiscal year, including about a $13 billion cut to the Department of Education's funding, and significant reductions, nearly 50% of NIH's funding, more than 50% of the National Science Foundation's funding, pretty significant research cuts across the board at other agencies. The Senate, in a very bipartisan way, has generally rejected the president's requests. They put more money into NIH, about $400 million more. They maintain National Science Foundation funding. They maintain Pell Grant funding. They maintain most of the aid programs, including things like TRIO and Gear Up that the president had asked to be eliminated. There will be, the House has not yet marked up their, out of committee, their appropriations bills, at least around the labor age education one. They will do that next month. When they do that, you will see a budget or a proposal that looks much closer to what the president has asked for. So far, the House has been following the president's budget request as top line, so meeting that $163 billion request. So a number of those programs I just mentioned, likely what we'll see is a House bill that eliminates some of those programs and has massive cuts in funding for others, especially in the areas of support for scientific research at NIH, NSF, and other places. What makes all this a little bit more complicated is we have not yet fully resolved the current federal fiscal year. And that's not because, for once, Congress hasn't acted. Congress, back in March, passed a year-long continuing resolution, essentially saying that they couldn't agree what to do differently this year, so they would simply move forward with funding the government at the same levels they spent in fiscal year 24. That should have resolved funding. It meant essentially that all of the money was allocated to programs along the same lines. But what we've seen is this administration takes a very different view of their obligations to spend the money Congress sends them. And as of this point, there are a number of federal grants that should have been awarded that have not gone out. There are a number of federal contracts that, even if they haven't yet been canceled, have not been funded, and a number of other contracts that have been canceled as well. So by some estimates, nearly $400 billion of funding allocated by Congress to the administration to disperse has not yet gone out as we approach the end of the fiscal year. The administration sent over what's called a rescissions package to Congress about 2 weeks ago. It was about a $14 billion request for money to be for a rescission to be put into effect, essentially saying of that $14 billion Congress sent, we don't have to now spend that out. About $5 billion of that was trimmed off, but things like money for public broadcasting, for USAID, for international aid, Congress agreed to pass that bill and say essentially the administration does not need to spend that money. Money is returned to the Treasury, or not really returned to the Treasury, just not spent out. We are expecting any day now to see another rescissions request coming from the administration. This one will focus much more on education. Education is supposed to be a big component of that. What the pieces of that will be, not entirely clear, but you can check, against where money has not yet been dispersed by the Department of Education and presume those are good places to look. So there are a number of programs that just had their funding released recently, but there will be a number of others, especially some unspent TRIO grants and other things that we'll expect to see a rescission request on. And then finally, as fun as the last 6 months with reconciliation has been, as soon as the first reconciliation bill was passed, there was already the beginnings of discussions about doing another or even 2 or 3 more reconciliation bills over the next year. This is in large part reflects the realities of Congress right now. There are bare, minuscule margins in both chambers. Neither party is in a bipartisan mood, especially given the administration's efforts. Democrats are going to be even less likely to work with Republicans on things like funding. And so Republicans are looking at reconciliation as possibly the only way to move legislation. There's also a lot of horse trading that went on in this reconciliation process, so a number of priorities that weren't addressed either in the House or the Senate. Members want to have another opportunity to bring those forward. It's widely believed that Speaker Johnson had made a number of deals with members of his party to get enough votes to pass essentially saying, we won't deal with this now, this is your priority, but we'll come back to it in a later reconciliation bill. So nothing certain there, but that talk continues to grow, looking at another reconciliation bill in the fall. And then finally, just a little update on issues around international students, and this is a particularly timely one. We are beginning to get in sort of the early estimates of what the impacts of a number of these proposals will be on international enrollment for the fall. But I'm going to just talk about what we've seen from the administration so far. The administration, I think most famously, had been targeting international students on student visas in the United States. By some estimates, as many as approximately 6,000 students being contacted and having their visas revoked based on alleged violations or criminal conduct. This was done through ICE and the Department of Homeland Security. As these efforts were underway, a growing number of legal challenges were put forward against this process, and it was revealed by ICE that the process they were using to make the determinations about which students to target, and I should say students and scholars, to target were based on using an AI match from a national criminal database to the names of students on the internet, on the visa lists. And what they found in many cases was that in some cases there were minor criminal violations by international students, often things like citations for underage drinking or unpaid parking tickets or having an expired license or expired insurance in states in which those are treated as misdemeanors rather than civil actions, whereas fine and penalty level below misdemeanor level non-criminal actions. But there are also a number of cases where international students were in that database because they had been witnesses to crimes, they had been victims of crimes, they had been charged with the crime and had that crime dismissed, so they were erroneously being targeted as having violated the law. So that program was suspended. In the suspension of that program, ICE turned towards tightening the screening of international students who are applying and faculty applying to come to the United States. They announced an expanded screening process, which requires students and staff looking to come to the United States to submit to a social media screen of their social media accounts. They have to ensure that their social media accounts, when you are applying for a visa, are reviewable by consular or embassy staff. You must make them public. They can't be private. And embassy staff, State Department staff are allowed to consider the absence of social media accounts as evidence that you are hiding your social media accounts. So if you don't have social media, they would say, well, you probably deleted it, so we couldn't see it. What they are looking for are public statements by applicants that express views contrary to U.S. National policy goals. That is exceptionally vague language, as you can imagine, and there's already been a few very publicly documented cases. The most famous one was a student from Norway returning to the United States to resume his studies, who had a meme that had a sort of derogatory picture of Vice President Vance on his phone. He had not created it, he simply had it, and he was turned away in, I believe, Boston when he landed in the United States. That process is now underway. All international applicants will be screened for that. The final thing that I talked about, what the impact will be on international enrollment and the ability of scholars to travel to the United States. We have seen the administration announce travel bans on, I believe, 12 countries at this point. There's constant discussion that they'll announce expanded travel bans on additional 35 countries. So far, those 12 countries don't send a lot of students to the United States. All told, in the last year, I think they sent only 190,000 people on any visa category to the United States. Iran is probably the country with the largest number of international students who would come to the US to study. Even that's not a huge number of students relative to certainly places like India or China. That said, what we have seen is the rhetoric coming from the administration, this expanded screening, the hostility to visa processing, the slowdown in applications that we've seen will almost certainly have an effect. And I've talked to institutions really of all types, including one, a small private institution that generally admits about or generally enrolls about 100 international students each year. And they so far, as of about a few weeks ago, had confirmation from only 4 of the 100 they'd accepted and expected to attend that they would be coming to the US this year. That's probably a dramatic example, but there was a report out, I believe, earlier this week that said expectations that international student enrollment will drop by about 15% when we know the final numbers in the fall. We are coming off 2 years of successively record-setting numbers of international student enrollment, a little over 1 million about 2 years ago and over 1.1 million last year. The predominant number, the largest number of those students are coming from China and India. Those are about 2/3 of all students coming to the United States. The other thing we've seen is that the international enrollment applications, at least at this point, to countries like Canada, the United Kingdom, other countries in Western Europe, have gone up significantly. International students are considering their options as to where to go, as well as students who are in the United States looking at whether they want to return home or go to other countries to further their studies. So certainly something that bears watching, and we'll have a little bit more data, end of October, November, when we start to finalize enrollment numbers nationally. And with that, I know we have some time for questions if folks have questions, and I'll just stop there.
So, John, thank you so much for that enlightening, though depressing, talk. Before we open up for questions, I actually have a quick question. So the November 1st deadline, is that statutory, or do you think President Trump will just kind of blow through that and ignore it?
So it is statutory. They're required to
Oh,
finalize the regs, but there are some provisions that allow them to, it's not quite get around it, but you can do something that's called expedited implementation, which essentially they could pass a regulation later, but say there's exigent circumstances that allow for that. It leaves them the susceptibility of having that challenged in court, because you're supposed to only really do it under certain circumstances. But yeah, I mean, I think we have every reason to believe the administration takes that deadline very seriously and will aim to try to meet that deadline. They don't want to go to court on this, and missing that deadline, they might have some ability to be a little flexible with it, but not a whole lot.
okay, thanks. So what we're going to do now is we're going to open up the floor for questions. We ask that you raise your hand so that Colin can unmute you. Do we have any questions, Colin?
Yes, we do. Luis Vilsicki, you can jump on. Yes, thank you.
Yes, I know a lot of that was awfully depressing, but I'm going back to what you said initially when you were talking about that parent borrowing. For a student who can borrow up to 50,000 a year, then can a parent borrow the 20,000 per year, so that theoretically, with parents' help, a student could have 70,000? Or does that go on top of the? Can you mix them together?
Right. The parent plus borrowing, that cap is wholly independent of the caps on the individual student Stafford borrowing. It's generally what it's been used for, and it is predominantly used in undergraduate education, but it's essentially where there has not been sufficient borrowing authority to meet total cost of attendance, the parents can borrow up to the cost of attendance, or up to $20,000 in this case, to fill that gap.
Okay.
As a parent, you can't borrow above the cost of attendance on top of other federal aid. So if there's only a remaining $7,000 or $8,000 of cost of attendance in that calculation, you can't borrow the full $20,000. I'll also say that is one where I think on implementation, there's a lot of concern with Parent Plus among members of Congress, and allowing for that borrowing. And there's all sorts of reasons why that are kind of worth going into, but that's one where I think there might be some congressional intent around further limiting the ability of parents to borrow on behalf of students when we get through the regulatory process.
Okay.
Other questions right now? Well, we have another question that came in. So John, what mechanisms does the One Big Beautiful Bill implement to hold colleges accountable for rising tuition and overall student costs? I know that this is a good question. I know that at one point in time there was discussion, I think, on the House side of the whole median tuition situation. So what happened with that?
Yeah, and it's an interesting point because in some ways, dental educators are part of the collateral damage of the way members of Congress perceive the debt problem. And there is a very strong belief among members of Congress that graduate education, especially master's programs, are used to generate revenue by institutions to subsidize other areas of operation. And they think that's, excuse me, they think that's in some cases almost predatory behavior. And so when you look at what the House proposed, the House had essentially said, instead of a fixed limit, the $20,000 and 100,000 or 50,000, 200,000, you would only be able to borrow up to the median cost of attendance for a similar program. So if you had a student pursuing a bachelor's of history at a private institution, and their cost of attendance normally would be, say, $30,000 a year, if the median for other bachelor's of history programs across the country was 23,000, that student would only be able to borrow up to $23,000, not all the way up to what their previous cost of attendance had been. That did not survive in the Senate version, and thank God it didn't. It would have been disastrous to implement if you think about a financial aid office trying to calculate cost of attendance per program against a national average that changes every year, and when those calculations would come from it, I mean, the administrative nightmare that would have been is one thing. But what we saw is this reflection, that split in the Senate bill between graduate and professional education, the lower limits, the higher limits, the aggregate limits. It really was this idea that they wanted to try to put a downward pressure on the loan availability for graduate programs, because again, what their thought is, well, schools charge what they charge so they can get away with, not what it actually costs to run these programs. And therefore, if we cap what's available in lending, schools will find a way to lower the cost for students. Again, it doesn't really reflect an understanding of how schools price or what that looks like, or certainly reflective of the cost that certain programs, especially those in the health fields, are really expensive to run and administer. So there's a lot of problems with their thinking, but that's what they were trying to do. And then the accountability piece, which I talked about, which essentially says your loan eligibility is tied to whether your program's graduates are earning at a certain level, is meant to do the same thing. We can justify lending to this program as long as what we see is that graduates are making enough money to repay those loans and they're getting an economic benefit from it.
Okay, thanks.
Mm-hmm.
Any other questions? I think actually we do have one or two in the chat. Are there any other hands up, Colin, first?
No other
Okay.
hands up.
So I think this will be our last question, John. This question came in. What specific strategies should colleges and universities adopt to proactively adjust to the new accountability regulations to ensure continued access to federal student aid and maintain institutional sustainability? That's a lot.
That's a lot. No, and
Throw your wizard hat here.
probably more than we have time to give a full answer to. But one of the things I'll say is we ran data at ACE, and we're refining some of that data now that we have a little bit more time, where we looked at every institution and every program at that institution for which there was reported scorecard data. And scorecard data, for those who don't know, does have outcomes like earnings, and qualify heavily. It's not a lot of programs that fail that accountability measure, and honestly, that both makes sense and is the way it should be, right? If you get a BA or an AA degree, you should out-earn high school graduates. If you have a graduate degree, you probably should out-earn bachelor's. There's states where that will be different for lots of reasons. You know, the example that often gets cited is there's a couple states in this country that are heavy energy field states where, you know, high school level recipients can earn six figures out of high school because the work is incredibly dangerous and they have to compensate people really highly to participate. So it skews some of those things. And I think we're gonna have to see some in the regulatory space, some accounting for where those aberrations will occur. But overwhelmingly, when you look at the programs that fail the test, they fall into 4 or 5 categories. And that's exactly what you'd expect to see, right? At the undergraduate level, it's the performing arts, where just very few students leave in those fields and go into high-paying jobs. It is the things like medical assistants, dental assistants, medical records people, teachers' assistants, and then you have the areas where you have people like social workers, where it usually requires a master's to get for licensure requirements. So you're competing against other BA recipients, but starting salaries for social workers are often in the 20s, 30s, $40,000 range. So the earnings are very low, not because they're not smart or talented or doing good work, just because that's what we pay as a society for those jobs, and yet they're balancing sort of the debt burden of the graduate education in comparison to a BA who might be a mechanical engineering major out of undergrad and earning a much better salary. So those are the things you could see coming. What it means for schools planning is look at those fields, right? Your dental education program is going to be just fine. Your graduates are going to go on and earn good money, and there will have to be some accounting for how residencies are handled and how other variables where that 4-year window might produce some false positives around earnings. But certainly both Congress and the department are aware of those cases around the health professions. Your program should be fine in this regard. As an institution, you should be looking at those other areas you know will be problematic and thinking about what you do. Are there ways to reduce costs? Are those programs where you can come up with alternatives to lending to support students or low-income students, at least in those fields? And frankly, are you offering your students a good opportunity? My president, Ted Mitchell, talks about this all the time, that sometimes giving a student the choice to do themselves, to do the wrong thing is not necessarily helping them in the first place. And if you need to accumulate a lot of debt to go into a field you're unlikely to be able to ever repay it, the school hasn't done you a whole lot of service either by allowing that to happen. So, schools will need to be thoughtful about what they offer, but again, it's going to be very targeted. So a lot of those decisions can be managed, I think.
Okay. Well, thanks so much. We really, really appreciate your time, and we look forward to working with you in the future. So,
Always happy to be here, and thanks so much for having me, and appreciate ADEA. So take care, everyone.
thank you.